Hi, I am Maya Van Rossum. I am the Delaware Riverkeeper, leader of the Delaware Riverkeeper Network, but also founder of the new national green movement, Green Amendments for the Generations. And I am very, very pleased to welcome you on behalf of those organizations, but also our key leading partners in the New York Green Amendment effort. Environmental Advocates of New York, who has really been at the forefront of this issue, as well as the Adirondack Mountain Club. This is the second in our three-part series of webinars. The first was focused on a general overview about the Green Amendment concept and the power and importance of Green Amendments. In this one, we're really going to dig into some of the legal benefits of having a Green Amendment in the state of New York. And then in the webinar 3 series, we are really going to hunker down and do some working with you for what you can do to help advance securing resolutions out of town councils and others that could help advance the passage of a Green Amendment in the state of New York. I'm going to encourage people, we're going to have everybody on mute because we have a lot of attendees. I'm going to encourage you that when questions come to your mind during the conversation, please write them in the chat box, and then we'll ask them after the fact. I'll pose them to Kate or myself if appropriate for answering. We're not going to open up the mics because it just gets a little too overwhelming with so many people participating. So just put it in the chat box and we'll be sure to get your questions answered. I want you to know that our first presentation from Kate Carrera with Environmental Advocates of New York is going to be a live presentation. And Kate is here with us and is going to be going through this with you live and be available again for Q&A. Our second presentation is going to be from John Smith with the Smith Butts Law Firm. His presentation is taped, so he's not here to answer questions, but he has a great body of knowledge to share. So with that, I think that we are going to go ahead and get started, and I'm going to introduce for you Kate Carrera. She's the Deputy Director of Environmental Advocates of New York. She's an attorney who's admitted both in New York, here in the US, but also in Victoria, in Australia. And she has a tremendous expertise in environmental climate change and water law. So she is going to be a very valuable resource as we continue to advance this Green Amendment movement. And with that, I am going to turn it over to Kate.
Great. Hi, everyone. Thank you, Maya. Thank you so much for the introduction. I'm really excited here today to talk about the Green Amendment and some legal considerations about it. I'm going to talk today about what a Green Amendment is, how it works in the context of the state constitution, and some legal considerations about how this amendment would actually operate. John Smith's presentation that will follow mine will go into a lot more detail about how a Green Amendment has been applied and operates in Pennsylvania. So, what is a Green Amendment and its key features? So firstly, it's an amendment placed in the Bill of Rights section of the state constitution that articulates some form of a right to clean air, water, and a healthy environment. Every state has a different articulation of these rights. In a few slides, I'll go over exactly what the New York language looks like. Its inclusion in the Bill of Rights is important because the Bill of Rights provides for our most important or fundamental rights, which protect us against government infringement and overreach. We often refer to these rights found in the Bill of Rights as inalienable, which means they cannot be taken away from us. We'll talk a little bit later in the presentation about different tests a court may use to determine if an infringement is justified. Another important feature about the inclusion of a Green Amendment in the Bill of Rights is that it means the right is self-executing. This means the right can automatically be used as a tool to enforce, and no state law is needed to operationalize, if you will, to make the right enforceable. Another key element, which we'll go into a little bit further as well, is exactly what the right limits, or another way to explain it is what the right protects against. Green amendments serve as a check on government authority, and it makes it clear that the government has the burden or the utmost duty to protect and respect the environmental rights of its people. So before we go into exactly what the Green Amendment looks like in New York State, I want to start to understand a little bit about the New York State Constitution, because that will help us understand how the Green Amendment fits in. Firstly, the U.S. Constitution reserves and delegates powers to the state, which we call federalism, and it's a foundational concept which the U.S. Constitution is based on, dividing powers among sovereign governing units such as the federal and state governments. And why do I mention this concept? Well, it's important because it helps explain the context and the content of Article 1 of the Bill of Rights of the New York State Constitution. The purpose of Bill of Rights is, as I mentioned on the previous slide, is to give the fundamental legal status to civil and personal liberties by placing limits on the exercise of government power. You will notice here that there are many parallels between the federal Constitution's Bill of Rights and New York State. Freedom of speech, right to assembly, takings of private property, excessive fines and bail, equal protection, search and seizure, the list goes on for a while. This was actually necessary for a reason, because for over 140 years, the US Constitution was interpreted as to only apply to the actions of the federal government and not those of the state. While this is not the prevailing view at the moment, the state constitution provides greater protections in these areas where the state has filled in the gaps, if you will, which they can do under the concept of federalism, because the states have the power to do anything that's not prohibited by the U.S. Constitution. So not only do we see that the New York Bill of Rights expanding and filling in the gaps of the federal Constitution, it also plays an important role in protecting additional civil liberties, as well as including rights that mandate the state to provide its citizens for certain goods. So, for example, you will see in the state constitution the right to workers' compensation or the right to play bingo. We often talk about these rights as affirmative rights, meaning rights to things. So in the context of affirmative rights, we can understand the right to clean air, clean water, and clean environment. A Green Amendment is an affirmative burden on the government to ensure citizens are protected and those rights are not infringed upon. While we're on the topic of the New York State Constitution, I wanted to look at one other provision that's relevant in the context of the Green Amendment, and that's Article 14, the conservation article of the New York State Constitution. This article of the Constitution is an extremely important one for conservation of forests and public lands, and it's often referred to, or at least parts of it are referred to, as the forever wild clause. It strictly prohibits the state's nearly 3 million acres of forest, protects nearly 3 million acres of the forest preserve. It's worth noting that this article formed a model for many other state constitutions in the protection and conservation of land and natural resources, but it does not accomplish what the Green Amendment would. So there's an important distinction of why Article 14 is not enough to accomplish what we're seeking here. So firstly, the subject matter covered by Article 14 is certainly more focused on land and natural resources. So arguably, we could argue that it's not as broad enough to cover other environmental areas such as air or climate change or healthy communities in general. But what's more important or more significant is that, in terms of a significant difference in limitation to Article 14, is that it's not part of the Bill of Rights of the Constitution. So if you recall, as I mentioned in the first couple slides, not being part of the Bill of Rights means the environment is not elevated to the status of a fundamental right and viewed more of an articulation of state policy. So the provision, Article 14, is not a self-executing provision. It's more of an articulation of state policy. And what it says is that the state or the legislature has to authorize the use of the provisions, and that's how it can be used and enforced against. So let's talk a little bit now about New York State's Green Amendment in terms of the actual language that's been proposed and the procedure to amend the state constitution. The proposed language for a Green Amendment in New York is 15 simple words. Each person shall have the right to clean air, clean water, and a healthful environment. It's pretty simple. So amending the Constitution in New York can occur one of two ways. Amendments to the Constitution may be proposed by the legislature at any time, or every 20 years, voters have the opportunity to approve the convening of a constitutional convention to propose changes to the Constitution. The latter process opens up the entire Constitution for review, and in 2017, voters had that option but rejected it. So the process we're pursuing is through legislative amendment. Last year, in April 2019, a bill sponsored by Assemblymember Engelbright and Senator Carlucci passed the legislature, which seeks to insert a new Section 19 in Article 1 of the state constitution. So if you recall from the first couple slides, the Bill of Rights ends at Section 18. A constitutional amendment through legislative action requires the passage of the bill by two consecutively elected legislatures, and then the language must be referred on to the voters in a ballot. So since we secured the first passage in 2019, we'll work to secure second passage in 2021 when a newly elected legislature is convened. If the second passage occurs in that legislative session, then theoretically the amendment could be put to the voters thereafter. Next, I wanted to spend a few minutes discussing how a Green Amendment helps better front-end decision-making. And John really goes into this a lot in his presentation to show how a Green Amendment had results in terms of the Pennsylvania cases that it was used in. So, as I mentioned before, the Green Amendment is a limitation on government authority, meaning whatever the government does, there's a positive burden to ensure that a decision does not violate a person's right to clean air, water, and environment. But what it is not a private right. It's not a private cause of action, meaning an individual cannot use this right to claim that another individual violated their right to clean water, air, and the environment through a private or individual action. This is an important distinction because this means an individual cannot use this right against, say, a private company or their neighbor or an individual. Saying that, what constitutes government action is quite a lot of things. So we're talking about the New York State legislature passing laws that need to be compatible or constitutional. We're talking about agency regulation making, agencies implementing or failing to implement a law or regulations, failing to take remedial action or cleanup somewhere, as well as authorizing actions of others, so issuing permits or issuing authorizations. So it actually is a number of things that the government decision making would be subject to. The next slide I wanted to touch on is how the Green Amendment interacts and is compatible with existing environmental laws, because that's something we hear a lot. You may be thinking to yourself, there are thousands of environmental laws across the statute book, federal and statewide, and why is a Green Amendment needed in the first place? So there are a couple of reasons. Firstly, a Green Amendment, and we mentioned this before, is superior to any law or regulation, which means it cannot be. It's more immune to shifts in in politics, right? So it's not easily repealed. It's not easily changed, as environmental laws and regulations can be changed depending on the government of the day. So that's an important aspect of it. And we also talked about the importance of elevating the right in the Constitution. Second, the majority of the environmental law complex, if you will, is based on managing, authorizing, remediating pollution and contamination. So environmental law is effectively accepting the outcome that pollution and contamination will occur, And what a Green Amendment does is actually is more of a paradigm shift in thinking about how we view environmental management and protection, because we shift the framework to a preventative model. So we're saying that we have the burden of looking at the impacts of actions and decisions before they actually happen, and that will effectively alter our decision making. I've included seeker here as just an example of how a Green Amendment may interact as well as be compatible with state law. So many of you may be familiar with the seeker review process. Environmental review of projects or activities proposed by a state must happen. There's a lengthy process of review that happens. And of course, citizens can challenge seeker reviews through Article 78 of the Civil Practice Law and Rules. Now, a Green Amendment would be an independent cause of action than a statutory claim that would come under secret. So they would be compatible with each other. You may have two causes of action. There are two ways to try to enforce against the infringement of the decision. And a way that they actually may be that they may interact is you may see that the Green Amendment would shift the review analysis under SECRA, especially in relation to mitigation and cumulative impacts. The next slide is just a little about another legal consideration that I wanted to briefly touch on, and I alluded to it in my first slide. Is to understand how the basics of how a court would look at challenges and how it would decide if an infringement to the right was justified. So while we are aware that our right, so for example, we're all aware that our right to free speech is protected under the federal Constitution as a fundamental right. However, we also know that that right is not absolute, right? There are limitations to, the Supreme Court over time and through interpretation has determined that there are limitations that are justified, right? We can't, we're not justified to slander or commit libel or use inciting words. So these are limitations that over time a court may place on somebody's fundamental rights. And this would be true with a Green Amendment, but what's important to know is because it's elevated to the Bill of Rights or fundamental right, it would receive the highest level of scrutiny by a court, meaning the burden would be on the government to show that the law that's being challenged has a compelling purpose and that law is narrowly tailored, or it's the least restrictive means to achieve that purpose. And that is the highest level of scrutiny a court could apply to that decision. And it's a high bar for the government to show. Now, this is just my last slide. And it's a little bit about how those 15 simple words would be interpreted. I've certainly heard arguments when the bill was being debated that the language is too broad, it's undefined nature, makes it impossible for decision makers to understand what actions constitute a violation of the right. While this is true, the concepts are broad. It's not unique for constitutional language to be drafted in such a way. Like any constitutional provision, the boundaries and limits, or the boundaries and its meanings, are determined through judicial review and interpretation. So courts are well equipped to address these questions. Of course, the inclusion of a Green Amendment in New York and subsequent challenges of it would provide further refinement, guidance, and understanding to how the terms would be applied. So that really brings me to the conclusion of what I wanted to touch upon in terms of the legal considerations of the Green Amendment. And I will pass it back to, and I think that you'll find John's presentation really useful and helpful to understand how this has actually worked in a state context. Thanks.
At this point, we're going to transition very quickly to John Smith's presentation against John. Again, John is a principal at the Smith Butts Law Firm in the Commonwealth of Pennsylvania. And the important thing for you to know is that John was part of the legal team in the Commonwealth of Pennsylvania that put forth the very powerful case that I talked about in session one that breathed legal life into Pennsylvania's, at that point, long ignored Green Amendment, and really is what sparked this entire national Green Amendment movement. As well as the authoring of the book, The Green Amendment. So very powerful resource. John has been asked to focus on the benefits of a Green Amendment for local government. So with that, we will run John's presentation.
Hi, everybody. My name is John Smith, and I'm an attorney in southwestern Pennsylvania in Washington County, Pennsylvania. And I've been asked to present a webinar on the advantages of a Green Amendment. Now, the reason I was asked to do that is that I've been involved with litigation revolving around the application of the Green Amendment, how it is used, and also because I represent local governments here in southwestern Pennsylvania that have to utilize the Green Amendment we have in Pennsylvania in order to make sure they're compliant with their constitutional obligation to their citizens. So to understand the advantages of a Green Amendment, we have to look at the states that have environmental rights amendments. And of course, being here in Pennsylvania with our environmental rights amendment, it sets forth that the people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. It goes on to say that Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. And as trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. Now understand that the first sentence is in this constitutional amendment is one that a lot of different states are looking at because it goes much broader than just natural resources, as the second part of the amendment sets forth. Now, why have one in the first place is that, as you understand, constitutional rights have legal teeth that statutes and ordinance do not. We all look to the constitutional rights, and we all look at the rights that the Constitution provides us as citizens. Now, to understand what that means is that we all know what our First Amendment rights are. We all understand what the Second Amendment rights are, that states or federal governments cannot pass laws that would interfere with those rights that are retained by the citizenry. So when you look at the Constitution, we look at it from an idea that citizens have these rights, but what the Constitution is really doing is restraining government action. It's restraining the government's ability to do anything that would serve to compromise those rights. And when we think about the environment, oftentimes people think of, from an environmental standpoint, that governments, whether they be state or local, are making policy choices as to whether they want certain uses to come in, a power plant, any sort of businesses that would put some sort of emissions out there, locations as to where these should go, foundries. We're looking at areas where typically elected officials are making these policy decisions as to what they think is best. What the constitutional right does is says that these are not policy decisions in so much as decisions that have a constitutional context to them, and they must be done in furtherance of that constitutional right. Now, to understand, why do states need one, or why do states have one? We have to look at a little bit of a framework and background of how Pennsylvania's Environmental Rights Amendment came to the forefront recently in some litigation. And I understand that, as I pointed out, that this Environmental Rights Amendment will cover a lot of different areas, not just oil and gas. It just is the oil and gas context that people have seen these environmental rights come to the forefront of the legal community and a lot of our local communities. So in Pennsylvania, and I bring this up because we had a 1984 Oil and Gas Act that preempted local governments. At least that was the idea. That for years, everybody operated under the understanding that local governments were preempted, meaning that they could not act or pass any laws that would serve to frustrate the state statute purpose. So in 2009, a case went to the Pennsylvania Supreme Court, And the court looked at the language and found that the state law did not preempt local government's ability to zone as to where oil and gas operations could take place. And because of that, the court invited this legislature and said, if you really wanted to preempt local governments, you would say so very explicitly. Similarly, we have a case in the town of Dryden in New York in 2014. And this case somewhat mirrors the previous case that we looked at from Huntley and Huntley in the borough of Oakmont. Here we have somebody coming into town and they want to conduct some drilling. They take some leases in the town of Dryden. Town of Dryden sets forth that they always never allowed oil and gas operations, but to be clear, they enacted a law in 2011 and held that you banned it in that particular town. So the oil and gas industry challenged that law under a similar analysis that we had in the Huntley case. And the court found along the way of Huntley that this specific language in this statute, we cannot say evidence is a clear expression of preemptive intent. And why is this case important is because in Pennsylvania, Act 13 happened after Huntley. So New York, in the absence of an environmental rights amendment, is living in the 2009 Pennsylvania world where all it takes is a legislature to change this. So a lot of times people look at the town of Dryden case and think that, well, the courts have already ruled on this. Local governments have the ability to regulate oil and gas, and they do under the current statute. But if a new statute is enacted in New York, similar to this one in Pennsylvania, then that right could go out the window. What Pennsylvania has that New York doesn't is an environmental rights amendment. So after the Pennsylvania Supreme Court invited the legislature to really preempt local governments, they took the bait and they did so. So if you look at the underlying section, it says to the exclusion of all local ordinances. So here, the legislature said, we're leaving no doubt we are now preempting. We are doing everything that the court said that we would need to do to preempt, similar to New York, that if New York, someone passes a law or the state assembly passes a law and the governor signs it, they could now preempt local governments and that Dryden case would go away. Here is just some more of the backdrop of the general rule and what it did from oil and gas standpoint in Pennsylvania. And the challenge was made, and also I apologize for this, it should also read, which we refer to this case as, Robinson Township Delaware Riverkeepers versus Commonwealth. And the Delaware Riverkeepers joined this case and initiated the action under the Environmental Rights Amendment. They brought this question to the forefront because their organization believed, correctly so at the Supreme Court level, that the Environmental Rights Amendment applied such that you could not have a state mandate local governments violate the constitutional rights enshrined in our Declaration of Rights under the Environmental Rights Amendment. Now, one thing I left out from earlier is that to understand in the Pennsylvania Constitution, we have what's called Article 1. And there are a number of different articles, but if an amendment or a constitutional provision falls within the framework of Article 1, it is considered our Declaration of Rights. And within those Declaration of Rights, it's synonymous with our Bill of Rights reserved to the people. So the Delaware Riverkeeper and their fine counsel, Mr. Jordan Yeager, brought to the table this argument that had never been advanced to the court with any success, that a law that served to make local governments violate their citizens' rights, this fundamental Bill of Rights, Declaration of Rights to clean air and pure water, could not stand constitutional scrutiny. So as the case proceeded to the Pennsylvania Supreme Court, you see in this first paragraph, it talks about what the court found: compelling exposure of otherwise protected areas to environmental habitability costs associated with this particular industrial use. The entirety new legal regime alters existing expectations of communities and property owners and substantially diminishes natural and aesthetic values of the local environment. Here, when the court struck down a state law, the only tool it had in its toolbox was a constitutional amendment. So in the absence of this, the state statute would have stood and allowing, in this particular case, oil and gas operations in all zoning districts throughout our Commonwealth. But it could have been any law. It could have enacted any amount of steel mills, cement factories, and it could have passed a law that said that we find that these are so important that local governments, you must allow these everywhere that they want to go. Because in the absence of a constitutional amendment that the statute would run afoul of, there was no argument. But luckily in Pennsylvania, we in fact had one in place. And if you look, and I kind of previewed this earlier, one of my favorite quotes from this case is this is from the Pennsylvania Supreme Court. According to the citizens, which they refer to our municipal clients and the Delaware River Keepers as, this dispute is not about municipal power, statutory or otherwise, to develop local policy, but it is instead about compliance with constitutional duties. Unless the Declaration of Rights is to have no meaning, the citizens are correct. So think about that. And even today, as we litigate these issues, local governments that want to allow drilling or other issues that may affect environmental rights of citizens, they always come into court and argue that it's our right to create policy as we see fit. We're elected officials, and as elected officials, if you don't like it, you can vote us out of office. And recently I argued, and that argument was advanced, and there are Pennsylvania courts that have gravitated to that, indicating that that is your choice. If you don't like the way government works, vote people out and put new people in to see the world the way you do. And I argued to the court in February of this year that, so Your Honor, if this local municipality comes into court and says, Your Honor, our law says that we are banning weapons, guns in our whole municipality. And not only that, Your Honor, we're banning the right of the citizens to come forward in a public meeting to speak about those rights. Clearly issues with First and Second Amendment constitutional rights. I said, Your Honor, so will you write an opinion? Or if you write an opinion now, the constitutional rights are merely enforced by way of the ballot box, will you do the same when those issues come before the court? And the court was shaking his head no, because he understood that once you see the environmental rights on par with rights that we understand as constitutional rights, it's easy to see the court's obligation. If it runs afoul of the Constitution, the court cannot point to the ballot box, but must make constitutional scrutiny analysis. And here, we're not looking at whether a local government decides whether this is a good or bad idea, but are they complying with the constitutional duty? And in this particular case, are they complying with citizens' right to clean air and pure water when they enact laws? There are several provisions in here from a local government standpoint that some of you may be interested in how this works. And the court, better than I can explain, has set forth that the Environmental Right Amendment accomplishes two primary goals via prohibitory and non-prohibitory clauses. One, the provision identifies protected rights to prevent the state from acting in certain ways, and the provision establishes a nascent framework for the Commonwealth to participate affirmatively in development and enforcement of those rights. So looking at the first part, the provision identifies protected rights. We have the right to clean air and pure water, and it's to prevent the state from acting in certain ways, acting contrary to those rights. The second provision is that they have to act affirmatively. The court just doesn't say, okay, well, you have this right to clean air and pure water. It puts an affirmative burden because of this constitutional amendment on governments, both state and local, to make sure that laws are in place to ensure that the citizens' rights are not violated. The court looks at to the plain language of which was our section, Article 1, Section 27, establishing these two rights, and declares the right of the citizens to clean air. It affirms the limitations on the state power. And while the subject of the right certainly may be regulated by the Commonwealth, any regulation is subordinate to the enjoyment of the right and must be regulation purely, not destruction. Laws of the Commonwealth that unreasonably impair the right are unconstitutional. So what we have is that, unlike a policy argument, if we have a state or local government mandating that certain businesses are allowed in certain areas, and we believe and we can prove that those rights are violating our clients' rights to clean air, we have recourse to challenge those laws, because these laws are not policy laws anymore, like we have in states in the absence of environmental rights amendments. These laws now have to make sure that they pass constitutional scrutiny. They have to be consistent when we look at all the facts. Did the state do something that runs afoul of the constitutional right to clean air or the constitutional right to pure water? And again, you can see, going back to the title of this seminar, this is an advantage. This is why this is in place, because this protects the wayward statute. This protects the wayward local ordinance, or this protects the inability or lack of desire from governments to enforcing and protecting those rights of citizens. Now, it wasn't always this way. For years, I think early 1970s, we had this constitutional amendment. The legislature and the courts looked at this constitutional right as more of an enabling statute. So you have a constitutional right, so that means that state and local governments have the power to pass environmental laws. And in this decision that came down in 2013, the court clarified that that's not necessarily the case. There is an affirmative, plain meaning that this right is a right that is the citizens, that a government cannot abridge. This goes on and pulls out some additional information, but this is a later case called the Pennsylvania Environmental Defense Foundation case. And because the Robinson Delaware Riverkeepers case was in fact a plurality, meaning that there were only 6 justices, and I was one of the lawyers that argued this case before the 6, and 3 of justices went for the Environmental Rights Amendment. 1 justice found a different reason and a different section of the Constitution to strike down the state law. So it was a plurality. So in the absence of a majority, we had a lot of courts that were not following the Environmental Rights Amendment, that they went back to the precursor days of, we don't have to follow this. There's a test that's out there. We can balance the rights, and citizens' rights are subject to some sort of judicial test versus the plain meaning. Well, in 2017, the PEDF case came down, and the court basically adopted Robinson from a majority standpoint. And what it also did in this case is, in the second part, and this is from the Commonwealth Court, they feature again a quote from the Robinson case. The first clause of the Environmental Rights Amendment requires each branch of government to consider in advance of proceedings the environmental effect of any proposed action or on the constitutional protected features. Now, what does that mean? Well, what we've used it at the local government level is that the obligation now is on the board. Typically, if there's going to be a law that's passed at the local level, they're going to pass a law that allows for certain uses to be in certain places, setbacks, where this is going to take place, how far the setbacks. And what they now have to contemplate is, if we do this, if we take this government action, will it have an effect negatively on people's constitutional rights? And so they have to weigh this. They have to do this before they enact the law. Also, when we see, at least in Pennsylvania, we have an applicant, and even for, let's say, a cement factory, oil and gas well applicant, and they come in and say, we want to put this use in this location. There's an argument that all they have to do is come forward, and if the ordinance allows for certain areas, that the applicant just has to show that they've complied with the ordinance. And the way it typically works is the objectors come forward and object, and the local government sits there almost as a referee and says, well, we decide, or a judge in a quasi-judicial function, and says, well, the applicant met its burden, and objectors, you didn't meet yours. Well, what we've now argued is objectors should not even have to show up, because the government obligation, because of this Environmental Rights Amendment, is to make sure that they don't approve anything that could harm people's rights. So in the past, an applicant would come in and the objector would have to point out all the potential perils to the application's proposed use. In the absence of the Environmental Rights Amendment, if no one showed up, if no objector showed up, and the applicant came in and makes application, the local government oftentimes wouldn't even ask a question. They would have no idea whether their environmental rights of anybody was going to be affected negatively or not, because it just wasn't on their radar to look. And it only became on their radar with the objectors coming in. But again, now I've argued this several times to several judges, objectors should not have to come in because the burden is on local governments now. The burden is on all governments to make sure that they don't approve or enact something that would be violative of people's constitutional rights. Now, here we are, and the advantages to environmental rights amendment for local governments. I've previewed some of them, and some of the big takeaways here are: one, to negate preemption. Because again, if we look at Pennsylvania, Pennsylvania won their case on oil and gas in 2009 because they could prove to the court that their local ordinances were not preempted by state law because it wasn't specific enough. New York made a similar argument, and they were both successful. The difference here is Pennsylvania went back to the drawing board, took out the local government's rights, and expressly preempted. Pennsylvania has the bullet of environmental rights amendment and their citizens' constitutional rights. New York does not. So again, in a future legislature moves to act on oil and gas, on any other industrial use or any use that could run afoul of water rights or clean air rights, in most cases, there's going to be deference to the legislatures that they follow their public or police powers, that they enacted laws for the benefit of everybody, local at the state level. And there will be no constitutional analysis. And from a preemption standpoint, they can come in and preempt fields. There are certain fields they can preempt, being the states. And what we argued is you can't preempt local government's rights to follow the Constitution. And that's where the Environmental Rights Amendment really got new life and moved forward. So what does that mean? Well, now Pennsylvania has the ability to zone for oil and gas and other uses to protect their citizens, to do this local analysis, and to keep certain things at safe distances, to put on additional conditions of, what we typically see for a number of uses. We may require fencing, we may require limitations of hours of operation, lighting requirements for all kinds of different uses. And we can do so, and I represent the local government side, under the guise of we have an obligation to make sure that our citizens' right to clean air, pure water, and to aesthetics values. And oftentimes the aesthetic part of this, even in this presentation, is kind of cast aside because the courts don't pay a lot of attention to it. But we do have occasions where people are going to construct certain facilities that people don't want to look at, and they're not aesthetically pleasing to certain communities. This isn't an art contest. What this means is they don't fit within a certain area. And what we can do at the local level is what we've done with compressor stations and cement plants. We've made them put up screening. We've made them put up landscaping. We've maybe pushed their setbacks back a little further so that they can't be seen from the road. All because we were successful in undoing a state law because of the Environmental Rights Amendment. And again, the approval process I previewed a little bit as well, is that now, if going back to the Oil and Gas Act in Pennsylvania for a reference, had we not had the Environmental Rights Amendment and this state law stayed in place and preempted local governments, the state law provided that oil and gas operations were permitted uses in all zoning districts throughout the Commonwealth of Pennsylvania. There was no approval process. If they made application, local governments had to issue the permit, and there were penalties for not issuing the permits. So local governments were going to be mere bystanders from an environmental standpoint and from a habitability standpoint of their residents. There was no way to undo what was going to be done by the state, and local governments were completely cut out of the process. Through the Environmental Rights Amendment, local governments now are back in the game. And not only are they back in the game in approving all uses and weighing their environmental features, they have the obligation to do so. So two different things going on here to take away from this is that, again, One is the citizens have this right enshrined in the Constitution, like all other constitutional rights. And when you think of other rights like the First and Second Amendment, they're much easier to understand why they're important. And not only do the citizens have this right, our court has determined that along with this right is the obligation of the state. So not only shouldn't the state pass laws that don't harm your rights, they should pass laws that serve to protect these constitutional rights. So going forward, we are advocating for people to understand, to look at the law, to look at the constitutional importance, and to not rest on any legislature that might be just sitting there waiting, and legislatures turn over all the time. We looked at this case and started it in 2011. Here we are in 2020. 9 years has moved, quickly we've gone from the Huntley case through Robinson Delaware Riverkeepers to now even noise about trying to change it again. So we are protected at the local government level. We are protected at the citizenry level because of the Environmental Rights Amendment that all states should look to pass. I'll take any questions if you have any.
And we're going to jump right into the questions and answer, or the questions, because we have limited time. Although thankfully, Colleen put up the screen so you can sign up for part 3 of the series if you're interested. And we will also be sending out a link to the first part of the series for those who may have missed it for the overview. So Kate, this is a question I'm going to throw to you. Will a Green Amendment require an opening up of the New York Constitution? I hear that state employees are concerned that the opening of the Constitution can give others a chance to take away benefits from employees, i.e. pension.
Thanks, Brad. Can you hear me okay?
Yes.
No, I don't think so. So the way that the state constitution is amended by legislative action. So the legislature has to pass a bill that provides for an amendment to the Constitution, and then that needs to go through 2 consecutive legislatures and then a referendum vote. So whether or not other interest groups have an interest in amending the Constitution in other ways, I'm not quite sure, so I can't speak directly to the pension question. I know that the state constitutions are reviewed at periodic points in time, and there have been times to review the New York Constitution previously, but this amendment in particular, I believe, would not do that.
Yeah, and so just to add to that, so Steve, there is, as Kate alluded to, there is the process of having a constitutional convention where you actually do open up the whole Constitution, and that could be one pathway to advance a Green Amendment. But as you're suggesting, it also allows a monkeying with everything, right? The entire Constitution is reopened. And there was, in fact, an opportunity in terms of timing. 2020 could have been the year for a constitutional convention that would have opened up the whole document and raised some of the concerns that I think that you're referring to. That I think that there was a lot of opposition from a lot of organizations to the constitutional convention approach. And so that really didn't happen. But as Kate has said, there is another pathway for amendment of the Constitution, and it is through legislation. And that's the pathway we're going. So we're adding to the Constitution, but we're not reopening the whole document. So there is no opportunity through this process to monkey around with the other pieces that people like. Tony had a question, and I was going to take it first, Kate, and then let you add on if you had anything to add. Tony said, considering Pennsylvania's Green Amendment, fracking has devastated much of the state, especially along the New York border. How do we strengthen New York's Green Amendment to avoid such problems? Can New York maintain a ban on fracking and other environmental industrial threats? And as Tony suggested, I think that John answered a lot of the elements of that question for people, but I really just wanted to touch on a few things. The most important thing to know about Pennsylvania's Green Amendment and fracking is that Pennsylvania's Green Amendment, actually the first Green Amendment in the nation, following the definition of Green Amendment that I've created, was It was actually passed in 1971. But for 42 years, until the Robinson Township Delaware Riverkeeper Network case, it was treated as, by the Pennsylvania Supreme Court, it was treated as a statement of mere policy. It didn't have legal strength. And so it was disregarded for 42 years. It was only in our legal challenge that John talked about that the Pennsylvania Green Amendment was reconsidered by the Pennsylvania Supreme Court and was actually given legal life and the same standing as the other provisions in the Bill of Rights section of the Pennsylvania Constitution. Unfortunately, between 71 and 2013, fracking already came to the state. And so we are now in the position of having to sort of claw back the ground case by case, challenge by challenge, using Pennsylvania's Green Amendment. But I absolutely believe 100% if we had had a living, vibrant Green Amendment, legally vibrant Green Amendment, before fracking was allowed to start in Pennsylvania, then we could have used the Green Amendment to keep it out. And so that's the benefit that New York has, right? New York right now does have legislative protection from fracking, but a future legislature could roll that back. If you add the Green Amendment, then regardless of what happens in future legislatures, the Green Amendment could be used to hold in place the current ground, using the science, using the facts to prove the point that if you were to open up the state to fracking, it would violate the constitutional right to clean water and air and a healthful environment. Do you want to add anything to that, Kate?
Yeah, no, I think that's right. And I think what I was going to mention in my presentation, I did, and I didn't, one of the things is that, like you said, a constitutional amendment is much more difficult to change. So while the state of New York had a moratorium on fracking and actually has codified that in the budget this year, actually codified the moratorium on fracking in New York State. A subsequent legislature could easily change that decision. And like you said, with the Green Amendment in place, it makes it much more difficult to justify some of these issues, even with a changing landscape of legislation.
And so, Kate, I'm going to let you take this one first, and then I might add a little bit to it if we have time. But Ira asks, I like including aesthetics in the amendment as in Pennsylvania's. Why wasn't it included in New York's?
It's a good question. So I guess my history with the Green Amendment in terms of working on.
All right. We seem to have lost Kate. Keep going, Kate. We just lost you for a sec.
Can you hear me now?
Yes.
Yeah, okay. The connection isn't great. I know that there was, and this is before my time in New York working on the Green Amendment, because I
was not
living in New York at the time. Yeah,
I can chime in. So there was an effort to try to get the legislators to do some more robust language like Pennsylvania has. And you can see down there, I've put Pennsylvania's language. It actually has a lot of really helpful language in terms of articulating guiding legal principles that allowed Pennsylvania's Green Amendment to be used the way John talked about it. But the legislators who have championed New York's Green Amendment really felt it was important to keep it short, sweet, and direct. And so that's why they settled with clean water and air and a healthful environment. And we at Green Amendments for the Generations in the Delaware Riverkeeper Network sort of went back with our legal team that had brought the Pennsylvania case, looked at that and said, you know what, it gets us what we need to really advance the kind of strong protections that we want. And environmental advocates for New York, Peter leading the way on that front, I think did the same analysis and reached the same conclusion. And so as a result, our three organizations joined forces to just wholeheartedly support. At this point, New York's Green Amendment has secured first passage, and to try to change the language now would actually really derail the process for securing a Green Amendment in New York by the end of 2021, which we don't think is wise. Because it does get you what you need. I do want you to know in the other states where we have Green Amendment proposals advancing, New Jersey, Maryland, West Virginia, Vermont, and other states where we're working towards proposals, including New Mexico, Maine, Connecticut, and others. Every single state has different language that's being advanced. We bring forth model language. There's discussion with the state to make sure that the language fulfills the unique qualities of that state. And so if you actually go to forthegenerations.org, you can see all the different language that's advancing in all the different states. And it's important and significant to make sure that, you know, each state's Green Amendment represents the characteristics and qualities of that state. Do you want to add anything to that, Kate? Sorry, just because I was there at the time, I thought it might be more efficient to go through it.
Oh, yeah.
You want to add on?
I couldn't sure if you could hear. I wasn't sure if you could even hear me because the connection seems very poor on my end. No, that's fine, Maya. Thank you.
Great. Okay, so with that, I think that we are at the end of our time. And so, sorry, I didn't press return, so Pennsylvania's Green Amendment came up. We're at 12:02, so I think we're going to close the webinar. We do encourage you to cut and paste the links into your browser so you can join for session 3, or go to the websites for Environmental Advocates of New York, Delaware Riverkeeper Network, or Green Amendments for the Generations, and you can also find a link to webinar number 1. So thanks everybody for joining us. We really appreciate it. And we hope you'll join session 3, because session 3 is where we're really going to dig in and talk about how you can hands-on help us secure the resolutions we need to advance New York's Green Amendment in 2021.